This is a California regulatory explainer providing an overview of the California rulemaking process. California has just over 200 state agencies, departments, boards, and commissions as part of the executive branch of state government that make public policy through their authority to adopt regulations. A list of those agencies that have adopted regulations can be found on the website of California's Office of Administrative Law, or OAL. Their website is www.oal.ca.gov. OAL's website provides direct access to California's regulations called the CCR, California Code of Regulations. And the CCR is organized under various subject matter titles, of which there are 28 such titles. And these 28 titles contain the over 60,000 state regulations that are currently in effect. California's Administrative Procedure Act, patterned after its federal equivalent, contains the required procedural rules for rulemaking, as well as administrative hearings that are conducted by these executive branch agencies and departments. Our APA is found at chapters 3.5, 4, and 5, commencing with section 11340 of Part 1 of Division 3 of Title 2 of the California Government Code. In addition, there are a number of regulations governing the APA found at the California Code of Regulations, Title 1, Sections 1 through 120. Now, OAL's website also includes checklists used by OAL to review regulations, as well as their publications such as California Rulemaking Law under the Administrative Procedure Act. Generally speaking, the authority of state agencies and departments to adopt policy, that is, their rulemaking, is defined and restricted by the authorizing statute. These statutes usually prescribe each agency's authority to adopt policy, and it's an established principle of administrative law that an agency cannot exceed its legally prescribed authority to regulate. On the other hand, many statutes confer broad powers to some of these state agencies regarding matters that directly affect the general public. There are also opportunities for interested parties to be informed, to observe, and participate in rulemaking activities of executive branch entities. In particular, interested parties have significant access to the rulemaking actions of state agencies by virtue of the APA in our government code. For example, every state agency is required to annually adopt a rulemaking calendar that's published on their website. Moreover, agencies establish interested parties mailing lists for notices of proposed rulemaking activities by that agency or department. California law also requires every state agency to satisfy the basic minimum procedural requirements that are established by the APA for adopting, amending, or repealing a regulation, unless that agency or department is expressly exempted from the APA by a statute. According to the Office of Administrative Law, California courts have long recognized that under the Constitution, the legislature may, by statute, delegate quasi-legislative powers to a state agency in the executive branch, so long as adequate standards are provided to guide the agency in its rulemaking activities. The agency develops four required documents during the preliminary activity stage, which are needed to initiate the formal rulemaking process. These are the express terms of the proposed regulation, i.e., the proposed text. Then the initial statement of reasons, known by its acronym ISOR. The fiscal impact statement, providing a fiscal analysis of the proposed regulatory activity, and the notice of the proposed rulemaking. These documents are initially filed with the Office of Administrative Law and published by the agency or rulemaking entity. Next begins a minimum 45-day comment period, an opportunity to submit written, faxed, or email comments on all or any part of a proposed rulemaking after the notice of proposed rulemaking has been published in California Regulatory Notice Register. The notice of proposed rulemaking is also mailed to interested parties and is posted on the rulemaking agency's website. According to OAL, a regulation must be easily understandable, have a rationale, and be the least burdensome, effective alternative. Also, a regulation cannot alter, amend, enlarge, or restrict a statute or be inconsistent or in conflict with a statute. Under the state's APA, an agency has an option as to whether it wishes to hold a public hearing on a proposed rulemaking. However, if an agency does not schedule a public hearing and any interested party submits a written request for one within 15 days prior to the closing of the written comment period, then the agency is required to hold that public hearing. And because of this requirement, an agency usually schedules a public hearing at the outset. The APA also requires a rulemaking agency to consider all relevant information presented to it during the comment period before it adopts, amends, or repeals any regulation. After this initial comment period, the agency will often decide to change its initial proposal, either in response to public comments received or on its own initiative. Before a rulemaking agency adopts regulatory changes, it's required to mail a notice of opportunity to comment on those proposed changes, along with a copy of the text to each person who has submitted any written comments on the original proposal, for those who testified at the public hearing or those who asked to receive a notice of proposed modifications. And the agency, of course, must also post this notice on its website. After the comment period, a rulemaking entity is required to summarize and respond on the record to timely filed comments. The summary and response to comments demonstrate that the agency has considered all relevant material that's presented to it before they adopt, amend, or repeal a regulation. And an agency may respond to a comment in one of two ways. Again, according to OAL, the agency must either one, explain how it has amended the proposal to accommodate the received comment, or two, to explain the reasons for making no change to the proposal. An agency's summary and response to comments are included as part of the final statement of reasons, known by its acronym FSOR. Thereafter, the agency transmits its rulemaking file to the OAL for review, and that must occur within 1 year from the date that the notice of proposed rulemaking action was published in the California Regulatory Notice Register. OAL then has 30 working days in which to review the rulemaking record to determine whether it demonstrates that the rulemaking agency satisfied all of the procedural requirements specified by the APA. Specifically, OAL reviews the rulemaking file for compliance with 6 statutory standards of review. Those are authority, reference, consistency, clarity, non-duplication, and necessity. OAL may not substitute its judgment for that of the rulemaking agency with regard to the substantive comment of the proposed regulation. Now, California's rulemaking process again is set forth in the APA and the accompanying regulations. There are numerous instances, as indicated, along the procedural process for interested parties to participate. Again, parties can meet with state agency staff prior to a regulatory project commencing to provide input even before the agency staff begins drafting any regulatory changes. Agencies and departments often utilize an interested parties process to review proposed rulemaking projects prior to commencing the formal OAL process. Even after the agency or department has completed its rulemaking process, there are still opportunities to be involved, such as OAL review of regulations, an appeal to the governor's office, or even ultimately challenging a rulemaking in court. So the rulemaking process in California is relatively transparent and affords consideration of comments submitted by interested parties.